You know what intellectual property is, right, Taplines listener? Of course you do. The name of this show, Taplines, is intellectual property. The Marvel Cinematic Universe, intellectual property. And of course, the hundreds of thousands of beer labels, logos, slogans, packaging, that's intellectual property, intellectual property, intellectual property, intellectual property. You get the idea. We're talking trademarks today, folks, at least in a general sense. I'm not a lawyer, and this isn't a legal podcast. It's a modern beer history podcast. But intellectual property disputes are actually kind of common in modern beer history, and today we're talking about a big one. On this episode, we're joined by the one and only Bianca Bruno, an editor of the venerable trade publication Beer Business Daily. Bianca's not a lawyer either, but she spent plenty of time in Southern California's halls of justice covering trials and motions and all that good stuff in a previous gig for a legal news service. In 2022, she stumbled onto the beer beat in a big way when a long-running legal dispute between San Diego's Stone Brewing Company, a somewhat notoriously litigious craft beer pioneer, and the Chicago-based macro brewer Molson Coors finally wound its way to a federal jury trial. At issue? Trademark infringement, intellectual property, etc. The trial was a real ripper, at least as far as these things go, and what it revealed about the state of Stone's business would set the stage for a once vehemently independent firm to sell out to a major multinational later that year. It's Beer Business Daily's Bianca Bruno, it's Stone Brewing Company, it's dropping a stone-cold stunner on Molson Coors, and it's all right here, right now, on Von Pair's Taplines. Well, we have something very interesting happening today, Taplines listeners. You know I'm not a lawyer. I'm Dave Infante. I'm a journalist. I cover the beer industry. We all know that. I'm joined by someone who's also not a lawyer, and yet we're going to be talking about lawyer stuff. We're going to be talking about the law. We're going to be talking about jurisprudence. But before we get to any of that, let's get to our guest. It's Bianca Bruno of Beer Business Daily. Bianca, welcome to Taplines.
Hello, Dave. Thank you for that intro.
Much. Yes, of course. Thank you so much for joining us.
I am not a lawyer. That is correct.
None of this is legal advice, all right? For all you freaks listening. We're going to be talking beer. We're going to be talking the law. But before that, let's talk a little bit about, Bianca, how you got strong-armed into becoming a beer journalist and even more strong-armed into coming on Taplines today. Bianca, you how long you been reporting? How long you been in the journalism industry?
Well, I've been a journalist for a little over 10 years. Mm-hmm. I was born and raised in San Diego and went to school locally. Graduated, kind of on the heels of recovering from the Great Recession in 2013. Not the best time to graduate, but of course, journalism has dwindled in the year, even more so in the years since.
Right. 2013 numbers look downright attractive compared to 2024 numbers if you're talking about, job openings and salaries and whatnot.
Exactly. But, we make it work. We're still here. We're here on Taplines.
That's right.
So I graduated then. I had a couple kind of part-time jobs at local nonprofit news was a big model at that time because companies were kind of grappling with dealing with the impact of the internet on news revenue and advertising and things like that. So I had a couple kind of stints at some nonprofit newsrooms for a bit. And then I landed at this national outlet called Courthouse News. And I was not trained to cover court. I don't know that I even wanted to cover court, but I wanted a full-time job in journalism, and that was kind of the way forward at that point. And I got it through, I think I applied through a listing on this website called journalismjobs.com.
I've been there many times myself.
Kind of interesting that the way people say you don't get jobs, I got a job.
Yeah.
And so basically I was the in-house reporter for San Diego. We had journalists stationed at courts throughout the country. Really, one of the only publications that covers court as thoroughly as they did in terms of, every courthouse basically had a reporter, which is unheard of, especially with the cuts to like local newsrooms and to their court reporting. So I did that for about 7 years.
When did it start? When did you start there?
I started there in 2015.
Okay, gotcha. Okay.
Right at the end. I was a court reporter in the Trump administration era. And so that dominated pretty much all of our reporting.
Yeah.
There was quite a lot of litigation related to that administration, some of it being in San Diego. Kind of notably, the Trump University case was filed here, but it was filed long before he ran for president, and of culminated with him winning and settling the case. We were really ready for it to go to trial. And then the family separation case was also filed in San Diego. So I covered that daily for about 2 years.
Oh my God.
And now I'm a beer journalist.
Cool. Yeah. That drove you to drink. And, yeah. Wow. So that was intense. Obviously, I remember the coverage, just the mainstream media coverage of the family separation case, was heart-wrenching and just incredibly upsetting. You were reporting on it. Were you in the courtroom for as the trial sort of developed on that stuff?
There wasn't
it never really went to trial.
Yeah, there wasn't a trial per se, but I was in the courtroom. I think at one point there were weekly, or maybe they were bi-weekly court hearings. And so basically the judge, they were called status updates. So that's any time that like both parties kind of have to present what's going on to the judge. And the status updates were how many people are missing, how many parents, how many kids, of the people we know where they are, where are they? And then once he ordered kind of these reunification efforts, he said, what's the status of that? They had, they were working with several NGOs in all these Central American countries to basically knock on people's doors to figure out where they were. And the case kind of continued since I left that job. And so I've not followed exactly where it stands, but I know recently, I think it was kind of wrapped up. And, at one point when I was still there, covering that daily, the judge, acknowledged there's going to be people that we don't know where they are.
I remember that turn in the case where, it was just like, well, that is just basically unfathomably awful, and no one really knew what to do with that, and it sounds like no one knows what to do with it even to this day, although I don't know exactly how the resolution went like you, because I also, I guess I haven't seen a story about it. But we're not here to bring you down, listener. We've taken you down a very grim road. That's my fault. I take full responsibility. But it's it's always darkest before the dawn, and that's true on podcasts, just like it is in life. And we're going to go from something dark to something a little more interesting, a little bit more on topic for what I'm guessing, listener, are your interests if you listen to Taplines, a podcast about modern beer history. Because, Bianca, after you spent 2 years covering the family separation case in the San Diego courts, you're in and out of the hearings, you're plodding through this emotionally burdensome and distressing case, you switched off to something else. You switched off to a case about beer. We're talking, of course, listener, as you know from the intro, about the Stone Brewing and Molson Coors lawsuit over Keystone, over the trade dress of the package of Keystone beer. Bianca, before we get into the case as such, I was hoping you could tell us a little bit about what your relationship with beer was prior to first getting on, on this being assigned to this case, starting to report on it?
My relationship to beer was that I didn't drink it much. And to this day, I probably drink it less than a lot of people who work in the beer industry. But I'm born and raised in San Diego, and so I'm quite familiar with the craft beer industry.
Yep.
I attempted to be a hipster when I was coming of age and when I turned 21 and drink some craft beer.
It's very important that you waited until 21. So any actual lawyers listening to this will be very pleased to hear that. Yeah.
I mean, I will say the first beer that I legally bought was craft beer, probably at Bevmo, and I just wanted to check out the shelves and definitely was interested in pretty labels that I could then turn into a vase for flowers afterwards.
Yes. Do you remember what it was? Do you remember the first craft beer that you bought?
It was a Portland brand, obviously, I think. And it was related to gardening because I was also big into community gardening at that point in my life.
You were really going for it. This was a whole phase for you.
I mean, this was the era of the heyday of Portlandia. So
yeah, that's
totally. So that sat on my kitchen table my senior year of college with some flowers in it. And so, kind of that. I mean, I also was keen on hard kombucha and still kind of am.
Really?
Which, and San Diego is like the mecca of hard kombucha companies. So
sure, but back in 2015, 16-ish? Like early on?
Yeah, well, it was even earlier than that, a little bit. So that's probably around the time there was mainly Boochcraft. So I think Boochcraft was one of the first kind of mainstream. If they have national distribution? I don't know.
I think so. Or at least semi-national. Yeah.
And so I drank a lot of their apple jasmine hard kombucha. It's very good. And we've got June Shine here, and so they came around a little later. And actually, the co-founders went to my school. I went to USD, and they're not. I think they might be a year or two younger than me. So hard kombucha territory.
You were an early adopter on hard kombucha. Okay.
Early adopter for sure.
So you had, to some extent, you were aware of the beer scene. It sounds like you dabbled a little bit, but we're not necessarily like a super big enthusiast or beer geek, as they were called at the time. What about Stone? What about Stone as a company? I mean, obviously has a huge presence, especially then had a huge presence in San Diego. Talk about that a little bit. What was your familiarity with Stone as a brewery?
My familiarity with Stone was probably mainly with my dad, actually. So my dad liked Stone mainly because he loves the name Arrogant Bastard, and he just liked saying it. And so he would buy his Arrogant Bastard ale, and it would sit in our, garage fridge. Their brew pubs in San Diego are beautiful. They're really impressive spaces. I mean, I think that's a objective statement. They're like incredible gardens with water fountains and
beautiful architecture, landscaping. Yeah,
they're really nice. I mean, that's the thing about San Diego is like we're outside all the time.
Yeah.
And I don't think that registers until you go somewhere else where people are not outside all the time. I mean, it's year round. It's not just in the summer. It's not just for 2 or 3 months. It's like we eat outside year round. Like that's part of our kind of on-premise experience, regardless of where you're going. And so they do that really well. And because of that, like I definitely had gone to events, like special events that were held at brew pubs for Stone, like friends' birthdays and stuff like that.
Yeah. So the case that we're here to discuss today, and the reason, actually, listener, that I know Bianca is because as I was monitoring the case, her coverage was just tremendous and was really steady drumbeat of scoops about the case between Stone and Molson Coors, and that's how we first met, or how we eventually met. Was I think I approached you and was like, that was awesome. Thanks so much for your amazing coverage. But the case that Bianca, you were covering started back in 2017. So right around the time that you were, I guess that was in the early days of covering Trump case, litigation and whatever. Stone filed a lawsuit against Molson Coors over the. Well, I guess what happened first was Molson Coors redesigned its Keystone package in 2017. That's where it ultimately started, or at the very beginning it started. Let's talk about the case a little bit, because by the time it actually went to trial, it had gone through a lot of twists and turns. But for those listeners who weren't paying attention to it and weren't covering it, they weren't in the courtroom with you as the trial played out. What was the basic squabble as you remember it from your reporting? What was at issue?
So, it's a trademark dispute, which is common in the beer industry and common in lots of industries, where basically in 2017, Molson Coors, which was then Miller Coors, revamped it's an economy beer, right? It revamped its economy beer.
Yeah, you can call it whatever you want here. It's swill, it's frat water, it's sub premium, it's economy, value lager, perhaps. I don't know, whatever people call it.
Value lager sounds nice.
Yeah, right.
They revamped their value lager,
nice,
Keystone Light, which is another thing that's funny. It's kind of an aside, but everyone in the beer industry, or I guess marketing people in the beer industry, call brand makeovers brand refreshes, which drives me nuts a little bit. I'm like, it's a makeover, just call it a makeover.
Yeah.
So they gave Keystone Light a brand refresh in 2017, kind of revamped all its packaging, still had like the little mountain scene and stuff, and had the words Keystone. But the crux of the case was that they separated, they being, Molson Coors and their brand makeover, separated the word key from Stone. So Stone was kind of big center stage on the packaging, and it said key separately above it, kind of, I think, to the left, and smaller font.
Yep.
And so, you'd have to be looking at it to see that it's Keystone, but it really looked like Stone.
Heavy emphasis on the Stone. So if someone's walking down the beer aisle or running into the gas station, they see a wall of Stone, you could definitely see how people might think the beer was called Stone.
Yeah. So it said Keystone. I think the side panel may have been clearer. I'd have to look at an image of it again. But, on the side packaging that people would kind of see and know when they go to pick up a 12-pack of beer or whatever, it looked like Stone, or Stone was emphasized. So Stone Brewing objected, obviously. This is also, it's in the later aughts, the late teens. Late teens.
Yeah.
So it's not
teens, whatever.
Yeah, not quite in craft's heyday. I mean, I guess it had already kind of been on the downward trajectory a bit at that point. I know they showed a bunch of numbers during the trial, kind of showing that.
Well, Stone in particular, even though craft, like as a segment, was still on the rise, but it was slowing, but was on the rise. Stone had, because it was one of the pioneers and was one of the, early adopters, and San Diego was a hotbed, early on, had kind of had its own fortunes that like presaged the broader craft slowdown, right? Like they were, and because I remember the stuff that came out during, anyway, I interrupted you, but right. So like, this is like 2017, 2018 or so. And I'll shut up now.
So, well, the lawsuit was filed in 2018. So it was filed like a year later.
Yeah.
And it was famously announced with this, I don't know, was it a YouTube video or a Twitter video posted by Stone co-founder Greg Cook, where he was like, we're taking them to court. Mm-hmm. And we're defending our name, and this is not Stone, this is Stone, showing their own beer and kind of comparing and contrasting and accusing the Molson Coors of wanting to kind of piggyback off of their good name and craft beer.
Right.
Of course, the case didn't go to trial until 2022. Which is after COVID. It was actually, I believe it was the first trial I covered after COVID, because the courts were severely impacted during the pandemic and were like shut down permanently for months. In San Diego, they opened up in a very limited capacity, like early summer of 2020. But had like a huge backlog of cases. Then they had, I think, maybe limited capacity when there were some early, resurgence of COVID in the fall. And so, everything was kind of delayed.
Yeah.
But it was my first trial after COVID. And I was like, back in the courtroom. Yeah. A daily slog a little bit. Trials are kind of like 9 to 5 deals. And then you have to go and write a story after that. So it's a long day. But I was like, I wanted to have fun with it because it's also beer. And comparing that to covering family separation and other things.
Yeah, you talk about it this being a slog. You went through a fucking slog. Yeah, this is a cakewalk compared to what you were covering before.
Well, and it's interesting because I remember intentionally I was like, I want to be a little more creative in the way I approach covering this case because it's beer. Because, on its face, trademark litigation is not exactly sexy or interesting or fun. But, it was all the details of this trial that obviously were interesting to me covering it and then all the people reading about it.
Sure. So set the scene for listeners who have never had the good fortune to have visited the San Diego federal courthouse. What's the vibe when you walk in? Tell us about like actually, the building, getting to the trial. Like, what are you doing every day while this is in trial and you're covering it?
You're going through security like at the airport. It's actually a massive courthouse that's fairly new. I think it opened in the 2010s sometime. So it's like a very nice courthouse. Oh no, actually this one is the old courthouse across from the very nice courthouse.
They put Stone in old busted courthouse. They're like, this is a fucking beer trial. They don't get the nice one.
You know what? I actually liked that courthouse though, because it's very stately and has like wood paneling.
Ooh, it has character.
Okay, so yeah, it was in the old courthouse, not in the new courthouse. You can cut that in the post, but it was in the old courthouse. The judge who presided over it is Judge Roger Benitez, and he's actually kind of a hard ass. And I was curious to see how he approached the case because my only other experience being in his courtroom was related to some very controversial gun legislation in California over where some gun rights groups sued the state because we had implemented a ban on capacity gun magazines. And he was kind of came to be known as a gun-friendly judge. And at one point I was in his courtroom when he essentially said he believed the Second Amendment guaranteed the right to own a bazooka.
Cool.
So he's an interesting dude.
By the way, the Taplines legal scholars have not yet told me what our official podcast position is on bazooka ownership. So that the jury is still out as far as the podcast's official opinion is concerned. But great to know that His Honor Benitez, has made up his mind on that one. Okay, noted.
No holds barred on that.
Yeah, Jesus.
So that was kind of my experience in his courtroom, was covering that legislation or litigation.
When you say he was kind of known as a hard ass, is this like a suffer no fools type of judge from the bench? Like, what? Give us a little color on that.
A little bit.
Yeah.
A lot of judges are, I would say most judges are kind of like that. But, you can just tell when they have a thing that they're super passionate about, that they're, and that happened to be guns in his case. And maybe it wasn't so much beer. So maybe he was a good judge on this case. I think he was pretty fair from what I recall, and the way he approved, or denied motions and objections and the legal things that happen during legal trials. But I think I'll let you ask me another question.
Okay, cool.
And we'll get into it.
Yeah.
I don't want to get too ahead of it.
No, not at all. So the case goes to trial finally in 2022. Things are opening back up after COVID, the sort of the heyday of COVID at least. And you're in the San Diego federal courthouse. The case draws Judge Benitez. And what's your recollection of the level? Obviously, this thing there's enough animosity between the two parties that they were not able to settle before this thing goes to trial. Do you recall if there was any, how much of a chance of, because what I was shocked about as someone who covers the beer industry but doesn't cover the court system, what I was shocked about is that this made it to trial at all, because so much stuff gets settled, especially when one of the when the defendant, or when either party, but especially the defendant, is a big multinational corporation like Miller Coors or Molson Coors, depending on where they are in the process, because they have an interest in not making disclosures public that's required in discovery and depositions and whatnot. Yeah. This is sort of a well-known thing even to the layperson, right? Is that for large corporations, the level of transparency and scrutiny that a case brings is also often more costly or less attractive than an out-of-court settlement. What was your sense, in those early days of the trial? Did you get a feel for, whether this thing was close to settling before it actually got there?
I am not privy to those types of conversations, but you are definitely right in characterizing it as being unusual for a trademark case, or one involving some big names and big publicly traded companies, to be going to trial where their business secrets are shown in court.
They're trade secrets in the case
Their trade secrets are shown in court.
And Keystone had trade secrets that came out in court, and it fucking rocked. Sorry, I'm getting ahead of myself.
They both did. I think the big thing that came out with Stone was the money that they owed to their, I don't know.
I think it was like a private equity note.
I want to say equity company.
Yeah, and it was a tremendous amount of debt. It was. I'm gonna pull up the actual figure here.
It was over 400 million or something?
It was
a lot.
It was in that neighborhood. I want to say 400, maybe 450 million. I should have that number. I'm sorry, listener, and I'm sorry, Bianca, for not having that handy here.
Too. Let's see.
Look at us. Well, listener, we're recording this on a Friday afternoon, so you'll have to cut us both some slack. But yeah, Stone has. It comes out in the trial that Stone is under this massive overhang. It has financial obligations that are quite large that no one really had understood. No one outside the company really knew, was afoot. They also, Stone, of course, was for craft brewing or craft beer enthusiasts or San Diego heads, was infamously vocal about its place in the craft beer. What's a nice way to say this? Like the craft beer sort of myth or the craft beer movement. Stone was a standard bearer. And one of the things even prior to this case that I remember just from covering it, covering the company and covering the industry is despite that fairly deserved, reputation or level of prestige, Stone had plenty of critics within the industry because they were fairly sharp-elbowed or perceived as fairly sharp-elbowed when it came to trademark suits. They were very vigorous in the defense of their, as a lawyer would say, they defended it vigorously. Their trademark,
very lawyery.
That's right. Again, this is not legal advice, but I'm doing the Charlie Kelly bird law bullshit. I'm faking it. They defended it vigorously. And so on one hand, you figure, okay, this is going to settle, and I was surprised that it went to trial, but maybe I shouldn't have been so surprised because Stone was really, as a company, was adamant about its trademarks, its intellectual property, and seeking remedy when that property was. They believed it was infringed upon. So that's a rambling way of moving on to our next question, which is you mentioned something that came out, the debts that or the financial obligations that Stone turned out to have that came out at trial. What were some of the things that you remember coming out about Keystone that they were forced to divulge during the trial?
I think Keystone.
I have one of my favorites, but
all right, let's hear your favorite.
So, and I'm relying on Bianca's reporting here, listener, because I was not there and she was. But at one point, Keystone's own, I forget which executive it was. It wouldn't have been Gavin Hattersley.
Although he did testify.
That's right. Yeah. One of the executives from Miller Coors was describing the average Keystone consumer. Do you know where you remember this by any chance? Was describing the average Keystone consumer and made the average Keystone consumer sound like basically like a bum. Like they, which I suppose is probably true. They slice and dice their marketing segmentation. They know exactly who's drinking their beer. And yes, I mean, Keystone is ultimately like a low priced beer. It's a value lager, as we were saying before. And hearing that come out of the mouth of the executive who is responsible for selling the stuff, I found to be pretty revealing. I'm going to pull up the quote real quick because it's too funny not to read off. Hang on one second. Do you remember that, Bianca? Is that ringing a bell?
I do remember that, but I'm not remembering either who said it.
All right, here we go.
Trying to pull it up. Okay.
Yeah, the guy's name was Bungie.
Okay.
I think it was an attorney for Miller Coors, Molson Coors, whatever. And this is what their attorney says when I don't know if he's asked this or he's putting this forward, but Molson Coors attorney, this is how he describes the difference between Keystone Light and Stone, offerings, and also implicitly between their customers. Quote, the products are not remotely the same in the same price range. Excuse me. The products are not remotely in the same price range, Bungie said, noting that Keystone Light costs 1/5 of Stone Brewing's beers. More than half of Keystone Light customers are not working, Bungie says, while 25% of its customers make less than $30,000 a year. Quote, we're not marketing to the same people. These are different beers sold to different people, close quote. I loved that detail. I think that's actually a passage from your coverage, by the way, at Courthouse News Service. I love that detail because it was said in very dry, lawyerly vocabulary, but basically this was just Keystone's own lawyer being like, Keystone Light drinkers are broke as hell, and they would never buy Stone beer because that's not what they're looking for in the marketplace, which is a fucking incredible defense of Keystone's allegedly similar trade dress. Not because it's wrong, right? Like that, I believe that, right? Like that feels more or less accurate on face, although obviously there are exceptions. But like, yes, these are different products and different price points, and they attract a different consumer. But because like, what sounds good or what sounds compelling as a defense in a trial sounds fucking terrible when you put it on Twitter.
I guess I put it on Twitter.
Yeah, I think you put it on Twitter. I think I wrote about it at the time, like about your coverage. Oh, it was fucking great. So that was my personal favorite revelation of the entire trial, because I don't know, like, again, you don't really get this opportunity very often to see big macro brewers go to trial on something like this that's like actually interesting, right? As opposed to, whatever behind the scenes bullshit they litigate. And two, like, there was just this huge dichotomy between there seemed to be a big dichotomy between how Keystone and Molson Coors expected the case to go within the courtroom, and certainly how it wound up was not how they expected, but also how they were perceived in the court of public opinion as it was taking place. I mean, not that everyone was watching this trial closely, but the beer industry was. The beer industry was wrapped over the course of the trial. How long was the trial? Do you remember, Bianca?
It was like a month. It was a few weeks, which is not unusual for a civil case. I mostly covered civil litigation, which can stretch on for a long time. And it was
because there's no right to speedy trial. Or it's not the same parameter. Right.
Yeah. I don't know that those criminal cases are speedy either, but
everything's relative, right? Yeah. The American judicial system groaning under the weight of the caseload. But the case was a jury trial. It wasn't 12 jurors, though. I think it was 8. Does that sound right to you?
It was 8. Yeah.
What's the... Sorry, go ahead.
Oh, I was going to say, I don't know. I don't remember the makeup of the jury. I think it was mostly women, though.
Yeah.
If I'm recalling correctly.
Were you there did you cover jury selection? Were you on hand to see them select, or is that before you started covering?
I think we don't really cover it from the perspective of actually writing a story, but I'll kind of show up and kind of monitor it a little bit. Mainly because it depends on the judge, and every courtroom is kind of its own little kingdom and territory, and the judge decides how they run the show.
Yeah.
But because they could pick a jury and then immediately start the trial,
You kinda
Sometimes
have
they'll
to
go
be there.
the next
Yeah,
day
yeah.
and start it the next morning, but you want to be there in case that's the way it goes. But in terms of knowing when to be there and keeping in contact with kind of both sides for the purposes of not missing anything. There was a lot of that going on too. But in terms of what were we talking about? We were
Well,
talking a bit
what
about
was I'm curious to know if you remember anything, like was there a theme to any of the questions during the selection process? Like were the attorneys asking about like if people were craft beer drinkers, if people had bad feelings towards big corporations? Like, were there anything that stuck out that were like memorable to you about that process that like sort of presaged the strategy of the case that each?
Oh, they definitely ask those types of questions.
Yeah.
Do you drink craft beer? Do you know what this brand is?
Do you like West Coast IPAs? Do you? Yeah.
I don't quite know how specific that got, but
Who's your favorite distributor in the Texas market? Yeah.
Very relevant for San Diego jury.
That's right. Okay, so the jury. Oh, by the way, something just came to me that was the other thing that I liked coming out in the disclosure. And this was, I believe, from an exec, or excuse me, from Hattersley.
Okay.
He was asked, and again, this I'm quoting from Bianca from your coverage at the time. This is Bianca writing. Hagee showed Hattersley, that's Gavin Hattersley, the chief executive of Molson Coors, ingredient lists for the 2 Molson Coors brews, showing they use the exact same 5 ingredients: water, barley, malt, corn syrup, yeast, and hop extract. Quote, you said one of your concerns was you wouldn't cover fixed costs of Coors Light. One of the most important reason volume of Keystone Light is important for the entire business is because it uses the aftermath of Coors Light to brew Keystone Light, close quote, Hagee said. He asked Hattersley, quote, sir, you've been in the beer industry for 25 years and are CEO of the second largest beer company in America and don't know how the beer is made? Close quote. Quote, I'm not in that detail of brewing the recipes. No, quote, Hattersley responded. So there you have. Well, tell us, maybe that jogs your memory. What was the significance of that situation, of that exchange there, Bianca?
Well, Hagee was Stone's attorney,
right?
Not Molson Coors. So that was a cross exam questioning probably of getting at showing how involved an executive is. I think part of Stone's strategy in the courtroom and outside the courtroom, like you've kind of set the stage, is showing that they're, committed to the craft of brewing, that, it's always been about the quality of their product. It's not about necessarily making a buck or, making the most money as possible. And so their value of quality ingredients is going to cost more. It's going to come with a higher price point, higher margins. It attracts higher income consumers, more educated consumers. So that's part of, I would say that's kind of like a lawyerly legal strategy of maybe painting a picture of not just like the facts. that wasn't necessarily an articulate way of saying it, but they were getting at that this is a company bent on the bottom line compared to a craft beer company that cares about its consumer, cares about its product, it cares about its standing in the industry, and does not want to be associated with this other brand.
Sure.
And they can't say that or didn't necessarily say it in those words, but I think that line of questioning kind of gets at that a little bit.
And what it got at for one step removed from the courtroom, or when it ricocheted around social media, was the very funny on face idea that the chief executive of a brewing company, although they would call themselves a beverage company, Molson Coors would, but a big macro brewer didn't necessarily know how to articulate the process by which one of its largest brands was made, which is just, I mean, that's just funny, right? Like, there's just like a real amusement to that, even though logically, as someone who covers the business, and I know that a company like Molson Coors or like Anheuser-Busch InBev or Constellation Brands International, these are big multinational, like integrated consumer packaged goods companies. Like, that's effectively what they are. And like, to some extent, even though, again, they wouldn't say this themselves, I'm editorializing here, they sell widgets. I remember we had Philip Van Munching on Taplines, whose father was he worked for a third generation importer of Heineken, that, was the exclusive importer to the United States, prior to Heineken taking it over as Heineken USA eventually. But his point was that, when after Heineken took over the U.S. operation of importing their beer to, stateside, they filled the ranks not with beer people, not with, folks who came up in distributorships or came up in breweries, or came up selling, at retail or whatever, but with MBAs from Colgate or from Procter and Gamble, who were selling Philip's joke was that they had like a hot shot like toothpaste marketer like working on Heineken at one point.
Hot shot.
I mean, he's marketer. The best. He was selling tubes of toothpaste like no one would believe. Yeah, right. Because again, and opinions differ within the business on how well that works, and it's different depending on the portfolio and whatever. But there is a line of logic, especially in the rarefied, Fortune 500 corporate air that a Molson Coors operates in. There is a line of logic that, the scale of the operation and the sophistication of the routes to market and marketing and all of sort of the pieces of the big machine require a skill set that is not necessarily a beer guy's skill set or a beer woman's skill set. Doesn't have to be a guy, all right, man. But is more aligned with, the broader consumer packaged goods landscape. So on one hand, what Hattersley says on trial, or in the cross-examination, he wasn't on trial himself, is very logical, and someone within the beer industry understands intuitively why a chief executive at Molson Coors is not going to get into the weeds and describe to you how Keystone gets made. On the other, sounds very funny when you tell it to someone who's not following the trial and who's not in the industry, which was my favorite, one of my favorite parts of the trial. But anyway, that's a big, long jag here, and I've taken you on it. Listener, I've taken you both on it. Thank you so much for being patient. If you stuck around, Bianca, you're not allowed to go anywhere. So, thank you for being patient, but my bad. But let's talk about, okay, so the trial goes for about a month. It's a jury trial. It's 8 people. As this thing, sort of winds to its conclusion, do you remember having a sense for who had put forth the winning case? I have to imagine, I mean, again, you're not a lawyer yourself. You're certainly not the judge or the jury. But like, you've been intimately involved in covering this thing. You have to have formed some opinions on like who's got a stronger argument. How are you feeling as this case started to wrap up?
I have a very diplomatic answer to that. Well, the thing is, I think Stone won because they had the trademark. They had the piece of paper and showed the piece of paper and said, look, the U.S. Patent and Trademark Office gave us this trademark. We continued to use it and continue to file whatever was required of us to file to maintain that trademark, to the point it became what's called incontestable, where you've used it, simultaneously for years and have kept up with, your registrations and
have
everything.
defended it, as we were talking about before.
And have defended it. Yeah. And have defended it. And I don't know why Molson Coors or Miller Coors at the time didn't have that. I'm sure they asked themselves that during the trial. Because they had proof of using the trademark in question, which was the word Stone, in relation to selling beer in the U.S. And so Molson Coors had proof that they used the word Stone without necessarily Keystone, because Keystone Light was called, Stones by college kids, partying.
You know how those college kids do, listener. Not me though. I was in the library. I don't know what you.
Not me. I was.
I don't know what you were up to at USD.
But they had proof that they had advertised the word Stone, not necessarily Keystones. They called it. Do they call it a box of stones
something,
or a rack of stones
prior to Stone existing? Prior
to Stone existing. In the 80s, they had this really cool, which was probably my favorite part of covering the trial, and I think maybe the most fun I had writing a story about the trial, is they had this archivist at Molson Coors who brought in all this physical evidence, all this kind of dead stock advertising, merch and swag and stuff from the 80s, showing that they used the word Stone on stuff that they, people would, consumers would enter a sweepstakes store, that kind of stuff. So they were using the word, but they didn't have the piece of paper. And I think it all came down to a piece of paper, because if you're asking a jury to decide a trademark case and you don't have the trademark, but you used it, it's well, you used it, but you didn't do what you needed to do to own it and to defend it. And Stone did. Because I think a lot of people, after I covered the trial, they're well, Stone won because it's in San Diego. And I'm no, they won because they had the piece of paper. And you're asking regular people without a legal degree to decide a case where they're supposed to use the law, and this is the law, and they followed the law, and they did it, to the letter of the law. And, you can have a trademark without owning the trademark, but, that's kind of a lot to ask of a regular person without a legal background.
Well, do you remember anything? Because there's also the matter of jury instructions too, how Judge Benitez advised the jury to consider the questions at hand, which is what the jury has to follow, not any sort of extra or any broader sort of perceptions they may have. They're supposed to be answering the question and delivering a verdict along those instructions. Do you remember in that level of detail? And maybe not. I mean, maybe this is just too in the weeds, but do you remember how he framed up the question for them as they went to deliberation? Was there anything significant in that framing, or is it more or less what we've described?
No, that's
So they just went in with the question of, was the trademark infringed upon based on everything? So he didn't ask them to disregard anything that they had heard during the trial. Nothing dramatic like that.
No, I don't think so. I do not think so. I'm trying to find the actual jury question they had to ask. It's part of the court record, so.
Should we hop on Pacer right now? Yeah.
It is on Pacer on page 20 of 50. Getting charged $50. So
no,
look it
thank
up,
you. Well, I think we got the gist. But so the jury goes in. How long were they in deliberation? Do you remember?
Not very long. I think it was a day. It might have been less than a day, and it actually coincided when I had a pre-planned vacation.
That's so fun for you.
I was gone. I was in Joshua Tree actually, and I had like pre-written 2 stories based on whichever verdict, happened. And so I found out that I think maybe an attorney texted me, or I forget how I found out that that the jury came back and had a verdict. And so I like told my editor, and then they filled it out a little bit more with some details, and then published kind of what I had already
Did you have
prepared,
the damages TK'd? You're like, Stone will be awarded TK dollars worth of damage. Yeah.
Well, and they were awarded a lot. They asked for a lot. They asked for $216 million, and the jury came back with $56 million.
Still an enormous amount of money.
What's that, about a fourth? A little bit. Yeah.
Which was I think one of the bigger damage awards in like a beverage trademark case.
I think it was the biggest, or one of the biggest trademark specific damages awards. So in a trademark case, because like you said, it's unusual for that type of case to ever make it to a trial to begin with. So it was like the biggest, or one of the biggest trademark damage awards. Yeah.
When you heard about the damages that the jury awarded, were you surprised? I mean, because as you say, on one hand, it's a record-breaking sum. On the other, it's roughly a quarter of what Stone requested. What did you make of the size of the damages?
Damages awards are strange because they're like asked to quantify something I don't think they're qualified to do.
Yeah, right. Sort of notoriously a problem, right? Yeah.
Can feel like a random number sometimes. So I don't know that I had like an opinion on the amount. I think people were a little surprised that Stone won. Although I do think both sides did show that they used the trademark, and that's why it went to trial, right? Because the judge couldn't say definitively, "Oh yeah, you're full of crap. Like this person's had the trademark," or "No, that's why it goes to trial, because there's a question of fact that a jury has to decide." So I think some people were just surprised that Stone won because they were coming up against Molson Coors, because Keystone Light had been around so much longer than Stone. It was around before the brewery was founded in the 90s. So I think for that, people were surprised that they won. I think the amount is kind of a little bit arbitrary. I think it shows that they... I don't know if they had to specify like what exactly the amount was going toward, like if it's for marketing, kind of, like brand recoup, or, what exactly they identified it as going to, because they asked for, past and future damages. So
Stone had showed that they lost, about, I think it was like 42% of volume of dollar sales on Stone IPA specifically since 2017, when the Keystone can came out. And there was a little bit of not funny business, but like, what's the Enron term? Creative accounting that was going on there, because obviously between 2017 and whenever they like showed their sales, I guess they probably would have gone through like 2020 or whatever. Like the whole craft beer industry had slowed down a lot, and especially pioneer brands like Stone had started to lose sales to younger craft breweries, as well as major strategics that had done a bunch of acquisition over the course of that decade. So like obviously like Stone IPA was not selling the way it once was, but like was that because 42% of customers were walking into the grocery store and confusing Keystone for Stone IPA, or was it because they were just not drinking Stone IPA for one reason or another? A little tough to say, but yeah, I mean, part of it I have to imagine was the damages were at least informed by, if not specifically designated for, like award for lost sales.
Yeah.
One more, I have sort of I guess like the coda to this, which I'd like to briefly talk about is, and this sort of segues into, I suppose, you, or the period in which you join the beer beat and leave the court beat. You transition from one to the other. But the aftermath of the trial is, I think, interesting, or would be interesting to our listeners for those who don't already know the broad strokes, because the $56 million in damages is a record, and it'll stay a record, by the way, listener, only for a few months, because shortly thereafter, Monster Energy Corporation, or Monster Beverage Corporation, whatever it's called, the one that makes Monster Energy drink and the Beast Unleashed and all that stuff, wins God, I forget exactly how much it was. Something in the hundreds of millions of dollars, about 140 million, maybe something like that, dollars worth of damages against Bang Energy, which would ultimately set Bang Energy on the course for bankruptcy. So Stone didn't hold the record for damages for that long, but they win this record verdict, this record award, $56 million. The amount that they owed to their creditor, which was I looked it up, VMG Hillhouse. It was an investment firm. They owed them $434 million. And as Stone's chief executive, Maria Stipp, testified at the trial, they had been shopping around for a potential buyer. This was huge news when it broke at the time. That was actually probably even more embarrassing for Stone than the fact that they were in the debt in the first place, because Stone had been incredibly vocal, including Greg Cook. Is it Cook or Koch? I don't even... It's Cook, yeah. Like Jim Cook. Got it. Yeah. Okay. So, Greg Cook, incredibly vocal, very antagonistic to other brewers over the years who had sold, had styled himself as, I don't know if he came up with this nickname, but people called him Beer Jesus because of the way he looked. I mean, there was a real part of Stone's genesis or origin story was this fiercely independent anti-corporate brand. So the fact that they had already explored sale prior to the trial was made real ripples in the craft brewing community. And then shortly after the case concluded, they did sell. They wound up being acquired by Sapporo Sapporo's U.S. subsidiary. I'm curious, like, as you sort of look back on the case, and I know you've gone the distance here, so thanks for coming along for this ride, Bianca. But like, as by way of wrapping up here, like looking back on the case and looking back at that outcome, now reporting on the beer industry for Beer Business Daily, as you shortly after would wind up joining the trade publication to cover this industry. What do you think, like, the lasting, I don't know, legacy or like the biggest takeaway from that trial was, like, knowing how it ended up, both this like incredible high for Stone with the surprise verdict, or to me a surprise verdict, and the big damages, and then shortly later being acquired and sort of forfeiting that mantle as a fiercely independent craft brewer that they had burnished for all those years. What do you make of that? Sum it up for us.
Not a loaded question at all.
We're here Taplines is here to get your take, man. I know you want to stick to the facts, but I want the Bianca Bruno unvarnished, unedited, unfiltered, and I know our listeners do too. I don't know. Give us how you reflect on that.
I mean, it's probably that you don't want your case to go to trial. You don't want a bunch of jurors, the majority who kind of looks like middle-aged women not interested in beer to decide, the outcome of your business. Because, Stone won, but then, like you said, they ended up selling anyways. And it's funny you bring up, that coming out in trial, because I was told not too long ago, like a year ago, by someone there that I went to a trial almost every day, but not quite every day because I did have to cover other things. I was a general court reporter. I wasn't a Stone v. Molson Coors trial court reporter. And so I did miss one day when apparently they had a Stone. I don't know if it was an executive or who it was, but someone testified kind of some details about talks that they had to sell, basically. And I wasn't there that day. So they were happy. They were happy about that at the time.
Thank God Bianca Bruno wasn't there.
They got to they got to reveal it on their own terms later. Which is funny. I mean, that's also, like you said, you don't want your case to go to trial because that's coming out in the public. And I can walk in and sit there and cover it. I covered the Bang trial too with Monster in Riverside. That was like one of the first things I did when I got hired at Courthouse News was drove up to Riverside every day in August when it was like 100 degrees and covered that case. So yeah, you don't want your case to go to trial. You want to like come to a little powwow agreement settlement with your fellow beer makers and beverage makers.
That's what they want,
I think,
Bianca. What we want as journalists is, see you in Discovery, motherfuckers.
That's true.
Well, I think that is a great place to leave it. Bianca Bruno, thank you so much. Folks, if you're not familiar with her work, because you didn't see her at Courthouse News, you can now find her at Beer Business Daily. We're so grateful that she switched sides from covering the stodgy and occasionally miserable slog of the American legal system over to the slightly more colorful, I would say, certainly more personable, but at times quite litigious Beer Beat. Bianca, thanks so much for joining us here on Taplines. It was a pleasure, and you're welcome back anytime.
Of course. Thanks, Dave.
Taplines is recorded in Richmond, Virginia, and produced by yours truly and Darby Seaside, who, along with the talented Shane Farrick, composed our delightful soundtrack. Just listen to it. I also want to give a quick shout out to the entire VinePair team, and especially co-founders Adam Teeter and Josh Mallon, editor-in-chief Joanna Sciarrino, managing editor Tim McCurdy, and art director Danielle Grinberg, who designed our lovely Taplines logo. And of course, a big thank you to you, yes, you listener, for spending time with us week in and week out. We literally couldn't do this without you. I'm Dave Infante, and I'll catch you next time.